Hello. Today, me and my friend are going to discuss about contract law and corporate law. A contract law is a written or expressed agreement between two parties to provide a product or service. A contract, however, can be enforced only if it meets four requirements, that is, agreement, consideration, contractual capacity, and lawful object. So, agreement is the parties must have reached a mutual agreement. There has to be an offer and acceptance. Consideration is something of legal value, which is money, property, or a service should be involved. And contractual capacity is both parties must possess the full legal capacity of to assume contractual duties. And the last one is lawful object. The purpose of the contract must be legal. The relevant issues to be discussed here are with whom Forthright enters into a valid contract, Bosworth or Pickwick, whether there is a valid contract aimed Foresight and Havoc Films with respect to The Day of the Yokel.
The Day of the Yokel is a novel written by Frederick Forthright, published by Metro Publishers. Forthright was not satisfied with the treatment that was given to him by Metro Publishers. Therefore, when he completed his second book, he wanted to explore another options. When Boswell met Forthright, he wanted Boswell to publish his book. At this stage, Forthright said that he would not settle for anything below 40 grants. Thus, as per Stevenson, Jakes and Company versus Macklin, there is only a statement that was made by Forthright and no offer was made. The editor of the Metro Publishers made an offer to Forthright that they are willing to pay him $50,000. A valid offer was made by the editor to Forthright, but as per Carlyle versus Carbolic Smokeball Company, the offer was said to be completed as the same was communicated. However, Forthright has not made any approval to the offer. Thus, as per Crown versus Clark, there is no acceptance by Forthright.
Boswell sends a letter to Forthright wherein Boswell has sent a standard form of contract along with $40,000 for Forthright's signatures. Now, the letter sent by Boswell must be considered as an offer. Against the offer, Forthright told Boswell telephonically that Metro is paying $50,000 for the book. Based on the conversation, Boswell offered him $45,000, so the new offer was made at $45,000. The contract was substituted by the sum 40,000 to $45,000 and Forthright signed the contract. The signature by the Forthright is the acceptance that is made to the offer of Bosold. The acceptance that is made must be valid under when it comes in the knowledge of Bosold. Forthright takes the contract to the local post office and handed over the contract. Later, Forthright returned and asked the postal worker to return the contract. Thus, the acceptance made by the Forthright is not complete as the acceptance was not put to transit. An offer was made by Pickwick for $45,000 and the same was affirmed by Forthright, and thus there is a concluded contract aimed them. There is no contract that is made between Forthright and Bosworth.
Havoc Films sent a letter to Forthright on 4th March, where it stated that it would like to make a film on the day of the yokel and would give $45,000 for the rights to Forthright. Now, there is an offer made which was completed as an offer was communicated to Forthright. Forthright sent a letter to Havoc wherein he accepted the offer and reserved the right as to the who will play the lead role in the film. The acceptance that is made by Forthright is not a valid acceptance. As per Hyde and Wrench, Forthright did not accept offer but has changed the offer terms. Thus, the confirmation is not valid acceptance. And now, this counter offer is the new offer. And if this new offer is accepted by Havoc Film, then a contract is made. And since the counter offer was not accepted, so no contract is made.
In a nutshell, we can say that there is a valid contract between Forthright and Pickwick, but there is no contract between Forthright and Boswell. Also, Forthright did not make a valid contract with Havoc Films, as Forthright made a counter offer which was not accepted by Havoc Films. So, there is just a contract between Forthright and Pickwick and not with anyone else.
Discussing about the Corporate Act 2001, it is one of the fundamental legal framework that is required by any country to carry on the function of corporation smoothly. When any company is incorporated, then a company is an artificial legal person in law. The directors are the mind and soul of the company and are the officers who are responsible to carry on the functions.
Relevant issues with regard to Mercedes and Greg are whether they have violated Section 180 of the Act, if Mercedes and Greg can protect themselves under Section 180 subsection 2 of the Act, and can they held of for breach of 588G of the Act of Joytronics becomes insolvent. Relevant law with regard to case of Mercedes and Greg are duties of care and diligence and duty of avoid insolvent trading. Duty of care and diligence is one of the common law duties must be complied by every officer, including the directors. This duty is also part of the Corporation Act 2001 under Section 180 subsection 1. As per Section 180 subsection 1, every company officers directors must carry all his acts with the care and diligence like a basic human being would have acted in the like in the situation when the directors is not able to comply with the duty, then as per section 1317E, the director must face civil penalties.
However, there is a defense under Section 180, subsection 2, which is also called business judgmental rule. Now, as per business judgment rule, if the director can prove that the section that is made by director is in proper purpose, there is no presence of material personal interest, and have the advice or expert opinion on that matter, sensibly believe that the decision is in company's interest, then the director is not found to be in violation.
And another law is duty to avoid insolvent trading. Under Section 580G of the Act, the director is found to be included in insolvent trading if, because his decision, the company became insolvent. As per the section, it is the duty of the director not to incur any debt under the company if already insolvent.
Electronics is a retail store and Flex, Craig and Mercedes are the directors and shareholders. Thus, all Flex, Craig and Mercedes have the major role to comply with their respective duties. The company is now suffering competition. In order to improve the business, Flex looks for a new warehouse store, the cost of which is quite high and out of the budget of Joytronics. Flex calls the board meeting and told Mercedes and Greg that the new warehouse is all the answer to the new problems.
So Mercedes is the non-executive director and is involved in the daily operations of the company. However, Mercedes and Greg has not complied with the said duties, as Mercedes and Greg has violated the statutory duty of care and diligence under Section 180G 181. Mercedes and Greg, being the non-executive director and storehead, it is their duty that before agreeing to the idea of Felix, that he must make sure that the information is correct and the decision of the board would be in best interest of Felix. But nothing was done on the part of Mercedes, and driven by the excitement of Felix, both of them agreed to the proposal. The acts of Mercedes and Greg were not what a normal prudent man would have acted in a similar situation. Thus, this is very clear breach of duty of care on the part of Mercedes and Greg.
Going to continue the presentation topic about contract law and its issue about the Mercedes and Greg. Mercedes and Greg cannot protect himself from the budgetment rule. The decision of the purchasing of the warehouse was not a sensible decision. The decision was not rational nor was made on the expert opinion or a proper survey. The business judgment rule cannot apply it. The second, Joytronic was not in the financial condition to purchase a warehouse. Mercedes and Greg has breached and liable to breach condition under 588G as an actor. Finally, I'm going to conclude this topic. The Greg and Mercedes have to be violated the duty of care and diligence. They involved in insolvent trading. So they have to face the consequences and have to penalized for the breaching of that duty. Thank you so much. This is our presentation.